We are live.
All right. Hi, everyone. Good afternoon. Thanks for joining us for today's webinar. My name is Richard Ellis Jacob, and I'm one of the team members here at Lawdiktat. So I want to take this opportunity to welcome all our guests and attendees to this webinar. The topic of the webinar is on the legal and practical aspects of dishonor of checks. So dishonor of check comes under the ambit of Section 138 of the Negotiable Instruments Act, and it deals primarily with the many intricacies of dishonor of check and punishment for dishonor of check and so on. So primarily in this webinar, we will be covering the basics of dishonor of check, how the section is applied, legal liabilities for dishonor of check, etc. I know there are going to be many takeaways from today's session, and to add to that, we would like to announce that we are offering an internship opportunity to be a part of our Lawdiktat team. You can get in touch with us and we'll share all those details, but the important part is that our screening round will be based on today's session. So stay with us till the end and try to gain as much knowledge as possible. Now I'd like to call upon one of my teammates at Lawdiktat, Dhruv, to take the session further.
Yeah, good afternoon, guys. My name is Krpc, and I am a legal intern at Lawdiktat. And I would like to introduce firstly to Lawdiktat, which is a project of Alpha AI, aiming to bridge the gap between law and technology, with a focus on variety of different aspects of the law in India. Lawdiktat hopes to create an atmosphere wherein everyone has easy access to their legal needs by introducing AI-based techno-legal tools in the legal field for students, practitioners, academicians, and others as well. We empower lawyers to unique courses to give them an edge over the theoretical and practical aspects of the legal field. Lawdiktat is also focused on designing AI-based tools for the legal fraternity and further extending it towards an AI-oriented person assistant to manage the cases. Our legal team can assist you in variety areas of law, including criminal law, property law, civil law, intellectual property rights, and many more. So if you have any legal situation that requires specialized legal assistance, feel free to contact our specialist who possesses extensive knowledge in their legal field. So today we have an expert with us, Advocate Harsha Sharma, partner at Sharma Dubey and Associates, and she has represented her clients before the Honorable Supreme Court of India, Delhi High Court, tribunals, and various other judicial and quasi-judicial forums. She is an alumnus of Guru Gobind Singh Indraprastha University, New Delhi, and she has stepped into this legal profession under the mentorship of notable advocates who guided her in understanding legal ethics, procedures, technicalities of law, and the relation between bar and bench, and much more. So now I would like to request Advocate Harsha Sharma ma'am to shed some light on the topic, legal and practical aspects of check dishonor and check bounce. And I would also like to request the audience that if you have any question during the session, please type them in the chat and we will bring them up after the session. So Harsha ma'am, you may have the floor now.
Thank you, team. Good afternoon, everyone. And good afternoon to the host and the team of Lawdiktat. I'm Advocate Harsha Sharma, practicing primarily at the Honorable Supreme Court of India, Delhi High Court, and the subordinate courts. Today, I'm here to talk to you on the topic of Section 138 NI Act. The session will be short and crisp. I won't bore you much. So let's start with the term negotiable instruments. These are two terms, negotiable and instruments. What is negotiable? Negotiable here means transferable from one person to another. And the term instrument means a document of title of money, which means that an instrument which can be transferable from one person to another in form of instrument, and it is a title of money, not the money in whole, but a title of money. That is why it is an instrument. Earlier, cash payments used to take place and for trade, etc. In order to avoid high and huge cash transaction and give legal effect to such transactions, this act was enacted. And as you know, by the whole term Negotiable Instrument Act of 1881, this law was enacted, this act was enacted in the British era. So there are three negotiable instruments mentioned in this act. This is a promissory note, a bill of exchange, and a check. We are today only covering the topic of checks, dishonor of check. So I'll proceed with that. Negotiable Instrument 1881 does not provide a proper definition of the negotiable instruments. Yet, Section 13 of the NI Act defines negotiable instrument as a promissory note, a bill of exchange, or a check. And since we are talking about check, Section 6 of the NI Act defines a check. A check is a bill of exchange drawn on a specified banker and is always payable on demand. One part is clear that it is payable on that this is a bill of exchange and it is drawn on a specified banker. The other term, which is a little complex, is payable on demand. What does it mean? As the words imply, the term means a debt must be paid when the payee asks for it. And the term payable on demand does not necessarily require to be in written form in any document. Let's say you are person A and I am person B, and you have a due debt to be paid to me. Then I will be asking you to pay me so and so amount, and you will be drawing a check, writing a check in my name, and that instrument, that check will be in my name. I will be the payee, you will be the drawer. I'll just mentioning these definitions after some time. So I am demanding you that money, that there is a debt which is to be paid to me, and you have to pay that debt to me, and you're writing a check for me amounting to that check. You will be drawing that check in that amount. Like, let's say 10,000 amount you have to pay to me, that was a debt, and you will be drawing that check to me. So who are the parties to a check? There are basically three parties. One is the drawer, second is the drawee, and third is the payee. Who is a drawer? Drawer is the one who draws the check, that is, who signs the check, who writes a check in a person's name. Then a drawee. A drawee in case of check is always a bank, because a check is encashed in a bank. It is encashed in a bank, so the bank is always the drawee. And then the payee. The payee is the person who receives the payment, whose name is written on the check, to whom a person is liable to pay a legally enforceable debt. So these three terms are clear, I guess: drawer, drawee, and a payee. So let's proceed with the essentials of 138 NI Act. If there is a check, and we are talking about dishonor of check, basically, the drawer must be legally enforceable. The drawer must have legally enforceable debt or liability to a certain amount to the payee, and a check gets drawn to discharge such debt or liability. Like I just told you about, who is a drawer? He is a person who has a liability to pay a debt to a person who is a payee. Secondly, second essential point is the check is returned unpaid due to insufficient funds, or it exceeds the amount to be paid from the account as per the agreement made between the persons. Let's say if I have to pay you a check, and then you have presented that check in your bank. Later on, you received a memo. A memo is a kind of small letter kind of thing which you receive from a bank, which says this check, this particular check number so and so could not be encashed because of some, the reason they categorize is insufficient funds in the bank, or the person who had to pay you that amount has stopped the payment. So in this case also, the check is returned unpaid, and it is mentioned in the memo the reason behind the check is not encashed. Thirdly, the check gets presented within 3 months from the drawn date. Once the check is drawn by a person A and a date is written on that check should be presented and must be presented in the bank for encashment within 3 months from the date which is written on the check. After that, it will become invalid. Fourth, notice should get filed within 30 days of receipt of information from the bank regarding the dishonor of the check. Once you have received the check memo from the bank that so and so number check was not encashed because of this reason, so the check is dishonored. It has been bounced. So you have received that memo. Within 30 days from the receiving of that memo, you have to send a demand notice to the person who had written that check, who is the drawer of that check, that this was the amount and this was the check number and this was the bank. On this date, we had presented the check and on this date, we have received this memo saying that there is insufficient amount in your bank. That is why the check could not encash. So here you will be demanding the money from that person to settle that debt for which he was legally liable to pay. Then, after 15 days of receiving of the demand notice, which you have sent, once you receive the memo, you will send the demand notice to that person. Within 15 days of receiving of that demand notice, he has to, within 15 days, he has to pay you that amount which was to be encashed, but it was not because the check got dishonored. So he has to pay you within those 15 days, because once those 15 days are over, after that, in 30 days, you have to file a complaint in the concerned court of law, basically in a magistrate's court, Metropolitan Magistrate. This is a part of the legal proceedings which are to be followed in the court. But right now, I am not covering that topic. I'm just covering how a check is dishonored, who is the drawer, drawee, or the payee, how much time frame you have, and what are the essentials which are there when a check is dishonored, and how to file a complaint. So these were some essentials. I'll be repeating these essentials for you. Firstly, the drawer must legally have enforceable debt or liability to pay a certain amount to the payee, and a check gets drawn to discharge such legal debt or liability. Secondly, the check is returned unpaid due to insufficient funds, or it exceeds the amount to be paid from that account as per the agreement made with the person or the bank. Thirdly, the check gets presented within 3 months from the drawn date. Fourth, notice should get filed within 30 days of receipt of information from the bank, that is the memo from the bank regarding the dishonor of the check. And the fifth one is the drawer of the check has made the payment within the 15 days of the receipt of the notice, then it's fine. Otherwise, you have to file a complaint case in the court of law. So these were the essentials of Section 138 NI Act. Now we'll have some exceptions. Exceptions of NI Act 138, Section 138 NI Act. There are also some exceptions when you can't file a case. So I'll be reading it out. The proviso of Section 138 provides with the exception where Section 138 is not applicable. There are few exceptions which I am reading here. The check is not presented in the bank within 3 days, within 3 months, or its validity period, whichever is earlier. First exception is there is a date on which the check is drawn. When the check is drawn, there is always a date on the check. If 3 months have been passed, and after those 3 months, you are presenting that check in the bank that so and so amount is to be encashed. If those 3 months have been lapsed, then in this case, there is an exception that you can file a case against that person. Second, in due course of the check, the payee or holder has not demanded the payment by giving notice within 30 days of receipt of information from the bank regarding the return of the check in unpaid. Like I said, you receive a check memo from the bank when your check is dishonored due to insufficient funds or the amount exceeds the amount in that person's account. So if you have not demanded money from that so and so person within 30 days of receiving of that check memo, then it won't be valid, or you can't file a case against that person, because there is a time frame of 30 days within which a person has to send a demand notice to the other person for demanding the money. Third, the drawer has paid the amount within 30 days of receipt of the legal notice of dishonor of the check. See, there is a time frame of 15 days, which is given to the person whose check was drawn, who had drawn that check, and the amount could not get encashed because it got dishonored. So within those 15 days, if that person has already paid that amount for which he was legally enforced to pay that debt, then the matter is sorted, it is settled, that you can file a complaint against that person because the amount you wanted is already been given to you and it has been settled. So here also, this is the third exception when you can't file a case under 138 NIA in the court of law. I have already mentioned, but I'll still go with the time frame or limitation in section 138 in NIA. There's a time frame for receiving the demand notice, for sending a demand notice, and for filing a case under 138 NIA. So let us start with the presentation of a check. The check must be presented in the bank within 3 months of the validity period. Second, demand notice from the payee to the drawer must be sent within 30 days from the receipt of the memo from the bank. Third, the payment which is due or the debt by the drawer must be paid within 15 days from receiving of the demand notice. This is for the drawer. Then this one is for the payee who did not get his amount in cash from the bank because the check got dishonored. Filing complaint within 30 days from expiry of the 15 day of the notice period. If a person has sent a notice demanding the money he had to get from that person, since the check got dishonored, after that he has to send a demand notice to that person. If he has not replied or he has not settled the amount which he had to pay, then from receiving of that demand notice, 15 days are counted. And after those 15 days, after the expiry of 15 days, a complaint should be filed by the payee in the concerned court of law. So we have covered the time frame, the limitation, and how a check is represented and how to proceed further when the check got dishonored. Now we'll be having the later part of this matter, which is compensation to be recoverable under section 138 of NI Act. Since I am not here giving you a brief on whole procedure of the court of law as to how we should proceed in a trial when a check got bounced or dishonored, and how a person has to file a complaint, because that would be too lengthy to explain now. So I'll be just going to the later part here, which is compensation to be recoverable under section 138 of NI Act 1881. So I'm reading it out. Under section 138, in case of dishonor of check, the court can direct the check drawer, one who had drawn that check, means one who had made that check in the name of another person, the court can direct the check drawer to pay the amount twice to the amount mentioned in the check to the payee. How a compensation is made? If a person had to pay me 10,000 rupees and his check got dishonored, then the court would direct that person to compensate me by giving me twice the amount, which is 20,000 rupees as a compensation for his check getting dishonored. Compensation awarded under Section 138 of the NI Act by the court is recoverable as a fine. And in case of default in payment of compensation, the amount can be recovered as the procedure provided under Section 421. So, what is Section 421 of the CRPC? It is the fine which is levied upon a person. This is 421 CRPC, and the amount is recovered under this provision. If a fine is levied to a person, then his assets can be attached. If he's not able to pay that amount to the payee, his assets will be attached, and that is how the fine will be paid. As you might be knowing that 138 matter NI Act is a quasi-criminal case. When a complaint is filed in the court of law, not whole of the criminal procedure is followed in these matters. That is why these are quasi-criminal matters. The very general and literal meaning of a quasi-criminal is a civil proceeding that results in criminal penalty, that is imprisonment up to 2 years. So it can be said that a quasi-criminal proceeding is a proceeding where some element of a criminal proceeding is present in civil proceedings, but not all the elements. It includes violation of the law or ordinance, family court proceedings, motor vehicle actions, regulatory offense, equity proceedings, contempt of court, etc. These are few examples of the quasi-criminal matters. We have covered the time frame, the presentation of check, receiving of memo, everything here, which is pre-trial, which is to be done, a procedure which is to be followed when a case has to be filed. This is before the trial gets started or a case is filed. But where to file a matter in case of NI Act? Jurisdiction has been a major issue in NI Act matters, and time and again, there are many judgments being passed by the apex court or the high courts that what should be the jurisdiction of a check dishonor matter. Earlier, when these matters used to get filed, it was scattered. Like if a person is living in one city and the other person who had drawn that check is living in another city, then there was a problem with the jurisdiction issue, where to file that matter. And there used to be multiple proceedings for one matter, as in for one subject, there used to be multiple proceedings. To avoid this multiplicity of proceedings, a judgment was passed in the year 2014, and I'm giving you the citation of that, which is 2014-2014-9 SCC 129, in the case of Dashrath Roop Singh Rathod versus State of Maharashtra. I'm giving a brief on this. The Supreme Court of India, in its judgment dated 1st August 2014, in the case of Dashrath Roop Singh Rathod versus State of Maharashtra, held that the territorial jurisdiction for cases relating to offense of dishonor of checks is restricted to the court within whose local jurisdiction such offense was committed. Such offense was committed in whose jurisdiction, as in which in the case, in this present context, is where the check is dishonored by the bank. I'll explain it to you. The jurisdiction in these matters is considered on the bank's branch. Let's say I have my bank's branch in Central Delhi, and I had presented that check which I received from a person in my Central Delhi bank branch. So the jurisdiction, the court jurisdiction will be at 30,000 because it is having the jurisdiction of Central Delhi. I cannot file a case in West Delhi, that is in Dwarka court, or in the West Delhi jurisdiction of Peace Hazari, but in the Central Delhi jurisdiction of Peace Hazari, because my bank's branch is in Central Delhi. Neither can I file any case in the jurisdiction of the place where the drawer is living or I am living, but in the location or jurisdiction where my bank's branch is situated. So this thing was cleared. I would suggest you to read this judgment. That is why I have given you the citation. This is a judgment which has changed the jurisdiction issue when it comes to the scattered and multiplicity of proceedings. So next is there are many cases in which the drawer wants to quash his complaint case, and in order to do that, he or she has to file a case in the High Court. Then for quashing, it is said that both the parties needs to be there. There should be a mutual consent for quashing. But in these matters specifically, in the matter of Meters and Instruments Private Limited versus Kanchan Mehta, it was held that if the accused is willing to pay the amount on the check default, but owing to the fact that mutual consent is necessary for compounding of offense under section 138 NI Act, the High Court did not grant bail, did not grant any relief to that accused just because the other party was not there, and it was not mutually consented that this matter will be compoundable or this will be quashed. So the Honorable Apex Court held that though compounding requires consent of both parties, but even in absence of such consent, the court, in the interests of justice, on being satisfied that the complainant has been duly compensated, can, in its discretion, close the proceedings and discharge the accused. The citation for Meters and Instruments Private Limited versus Kanchan Mehta is 2018 1 SCC 560. So I guess I've covered the topic of presentation and jurisdiction and compensation here. If there's any questions, I can take questionnaire here.
Hi, ma'am. Thank you so much. I'll go ahead and ask some questions from the audience.
Please.
The first question is, can a person who stood up as a guarantor be held liable under Section 138 of the Act?
Okay, there are many matters pending and have been decided regarding this question. Actually, in May 2022 itself, the Supreme Court of India has held that a person cannot be convicted for the offense of dishonor of check under Section 138 NI Act merely because he stood as a guarantor for any loan or for any person. Because in 138 matters, specifically in 141, Section 141 of the NI Act, vicarious liability cannot be fastened upon a person. And here, a vicarious liability will be fastened upon a guarantor if he is liable to pay under 138. So no, he cannot be convicted merely because he stood up as a guarantor. And the matter in which this thing was decided was in May 2022 itself by the Honorable Supreme Court of India in Dilip Hari Ramani versus Bank of Baroda.
Thank you, ma'am. The next question is whether the court can wind up proceedings of check bounce and discharge the accused on the satisfaction that the check amount with assessed costs and interests are paid.
Sorry, could you please repeat?
Whether the court can wind up the proceedings of check bounce and discharge the accused on the satisfaction that the check amount with assessed costs and interest is paid. So the accused person pays the assessed cost and the interest. So on this, can the court just simply wind up proceedings without consent of the complainant or whatever and discharge the accused?
Yes, like I have mentioned that in the case of Meters and Instruments Private Limited versus Kanchan Mehta, the apex court held that though compounding requires consent of both the parties, both complainant and the accused. Accused here is a person whose check got dishonored. So consent of both parties, even in absence of such consent, the court, in the interests of justice, on being satisfied that the complainant has been duly compensated, it should be on the discretion of the court that the complainant has been compensated, can it, in its discretion, close the proceedings and discharge the accused. You may show this citation, Meters and Instruments Private Limited versus Kanchan Mehta, 2018, 1 SCC 560.
Ma'am, can we move to the next question?
Yeah, please.
Okay. The next question is, can the complainant still seek extra compensation if the accused is ready to deposit the check amount with nominal interest? So if the accused person is ready to deposit the check amount with nominal interest, can the complainant still seek extra compensation?
Okay. So firstly, this will be on the discretion of the court. But there has been a recent judgment by the High Court of Jammu and Kashmir in the matter of Yasir Amin Khan versus Abdul Rashid Ghani for extra compensation. And to resolve this issue, it was held and it was said in that in this particular judgment that the legislature has given discretion to the magistrate to impose a sentence of fine which may extend to double the amount of check, and therefore the sentence of fine whenever imposed by the criminal court upon conviction of accused under section 138 of NI Act must be sufficient enough to adequately compensate the complainant. So, like it has been said that the sentence of fine whenever imposed by the criminal court upon conviction of accused under section 138 on the discretion of the learned magistrate, it should be adequate enough to compensate for the complainant, because the amount of check and the date from which the amount under the check has become payable, along with payment of reasonable interest, may serve as good guide in this regard. And to make it more consistent and uniform, it is always advisable to impose a fine equivalent to the amount of check plus at least 6% interest per annum from the date of check till the date of judgment of conviction should be added to that amount, which is to be compensated. I hope this is clear.
Thank you, ma'am. The next question. Can a single complaint be initiated for the dishonor of multiple checks?
Yes, it has been in a judgment of 2019. It was directed in the citation is 2019 for CIV .cc 508 ALL. In case of more than one check as payment of one transaction, single complaint maintainable up to 4 checks, which means in one complaint, 4 checks complaint can be constituted, as in 4 complaints, as in 4 check amounts dishonored, then that say in the same transaction, then it can be constituted in one complaint, not more than 4.
Thank you, ma'am. The next question. What does the notice of check bounce consist of, and within how many days should the legal notice be sent to the other party?
Like I said, when I was covering the topic, I would like to repeat this because this is important. Once a person receives a check memo from the bank that so and so check has been dishonored for so and so reason, maybe insufficiency in funds or a wrong signature, or the amount exceeds the amount in that person's account, then within receiving of that check memo, within 30 days, that person has to send a demand notice to the drawer, to the accused. Later on, he will be called as the accused if the amount is not settled or paid. So there are some basic things which are included in a demand notice. Firstly, the date, the simple format. Firstly, the date, then the name and address of the drawer, then that pays own information. Then in the body, you should mention the check amount, the check number, and also the bank's branch from which you have received that check memo. And it should be filed by your counsel, as in sent by your counsel.
Thank you, ma'am. The next question. What other remedies are available to the complainant if they fail to send a legal notice within the limitation period?
You can always file a civil suit for recovery of money.
So it's a different limitation period on that?
Yes, the limitation is 3 years.
Okay. The next question. As the decriminalization of Section 138 is a topic of debate, do you think it should be decriminalized?
See, there are many people, many senior advocates have given their words on this thing especially. And for that, I think we should focus on major criminality and dilute the provisions under 138 NI Act, so that the judicial system is less burdened. So decriminalization of minor offenses can make a big impact on the pending backlogs of the court cases. And but to this also, I feel that personally feel that major frauds where it is very much evident that the person had no intent to repay his debt, in those cases where the intent is there, criminality should be considered, because we know that the criminal cases gives more pressure to the person, to the accused. So an amount should be specified, and where economic impact is more, like let's say 2 lakhs, more than 2 lakhs amount should be considered in criminality. It will, this is a baby step, but it will impact on large cases.
Thank you, ma'am. The next question, what remedies would the accused have if their check bounces for a reason other than insufficient funds, and then after it bounces, they no longer have the funds readily available? So it bounces not for insufficient funds, but then after the bounce, they don't have the funds anymore. And would this come under section 138 as well?
If the check is dishonored, then it is bound to come under the 138 NI Act, because this is a specified provision for that issue itself. So if this is done and he doesn't have the financial ability to, he's not in a capacity to pay that fund, then in that case, time can be granted to him that in 2 months, 3 months, this should be settled. And after that, his assets are attached to get that fine or that money from that person. Like I said, in CRPC section 421 is applied for compensation in 138 NI Act matters.
Thank you, ma'am. So what remedies are available if a non-CTS check is issued?
As per the guidelines of the RBI, there was a notification or circular passed in 2013 that non-CTS checks are not valid anymore. So bank would not receive it from a person. So there is no question of that at the moment, because it has already been declared invalid in 2013.
So it would just like that be invalidated.
Right.
Next question, is there any remedy available to charitable organizations in case a check issued to them is dishonorable?
Yes, it is there. Let's say if a trustee has drawn a check, if a person has drawn a check who is a trustee and it has been dishonored, then the trustee beside the trust is liable under section 138 NI Act.
What about in cases so similar to this, if an individual is offered a gift in the form of a check, if this bounces, do they have any remedy?
Yes, in 138 NI Act itself.
Same thing. Okay.
Because it shows that there was no intent to pay. It is based on the intent. If there was no intent to pay and the check was given as a gift to a charitable foundation, then also NI Act will be applied because the check got dishonored.
Yeah, thank you, ma'am. Next question. What, if any, are the remedies available for a complainant if the accused announces a moratorium under section 14 of the Insolvency and Bankruptcy Code?
Okay, I have read this recent judgment of 2021 itself. The citation is 2021 6 SCC 258. So I'm referring to the Honorable Supreme Court's judgment in the matter of P. Mohanraj versus Shah Brothers Ispat Private Limited, wherein it was held that the moratorium provision contained in section 14 of the Insolvency and Bankruptcy Act Code would apply only to the corporate debtor. The natural persons mentioned in section 141 continuing to be statutorily liable under the NI Act. So the corporate debtor के ऊपर ही apply होगा ये, and to the natural persons mentioned in section 141 in the NI Act in that particular complaint.
Thank you, ma'am. The next question, how is demand notice different from legal notice?
Demand notice is different from legal notice. See, demand notice is particularly for the money you're demanding money here. In NI Act also, there is a demand notice which is to be sent within 30 days from receiving of the memo. So it is different from a legal notice because a legal notice is not amounting to a demand of money only. It can be anything other than the money also.
Yeah, thank you, ma'am. That's all the questions we have. If anyone has any more questions, please put them in the chat, and we'll just wait, I suppose, like half a minute for that.
Yeah, hi, Miss Harsha.
Hello.
I'm Akash.
Hi.
So I have one of the questions. So what happens now? The Supreme Court or they have the government, they have showed their interest in having fast track courts, right? For
Show their
the
trust.
fast track courts for
Right.
138A. And we know there's so many backlog the district courts because of the 138. And even the Bombay High Court, they have ordered the magistrate to start the fast track court. So what are your views on the same?
I think it's good because yesterday itself I was reading this judgment which has been passed in uh, May 19th, which has been passed in May 19th, and which specifically directs the districts and the high courts to make a committee of 25 special courts for this matter. So you see, there already been many pending backlogs of matters in Indian courts, and almost 30% of those matters are 138 and under 138 NI Act. So I think fast track trial in these matters would be beneficiary.
All right, thank you.
I can tell you the name of the number of that case, which has been just the one which I was telling you about.
And moreover, I have one more additional question. So what happens? Most of the businesses, they have the matters of the 138A. Sorry, 138, right? NIA. So can you suggest some measures which they can follow so they don't have to follow the lengthy procedure under 138?
I think they should settle.
Like or ADR?
Not just the ADR, but they should settle directly or should pay the amount, because in two of my recent matters, there were two builders and they had settled the matter with 22 of my clients by sending them the principal amount in installments, and it was settled and an agreement was made that the interest will be offered later on, but till then no judicial proceeding should be carried on by the home buyers.
All right.
Yeah, thank you, ma'am. I think that's it for the questions. I'll pass it on now to my teammate Dhruv.
Yeah, thank you, ma'am, for sharing your experience with us. We are sure this is going to support our audience in building their confidence about check bounce and dishonoring judge checks. So it was truly an edifying session with you. Our audience truly gained an experience that will last with them. And I also want to thank all the attendees who joined the session and came with us to the end of it. I would also like to inform all the participants that you all will receive a certificate of participation, for which you will need to fill the form that will be shared now in the chat box. So please note that this link will expire in 5 minutes.
Okay, thank you, Team Dictate. Thanks for inviting me. Take care.
Thank you, Advocate Harsha. It was nice having you.
Thank you so much.
You may now leave the platform.